Another edition of the Daily Harmon. Yeah, no, whatever. Okay, so today we'll talk about a couple of things. I did block Remy. He made some kind of snarky comment, and then I read today, just today, an old PM somebody sent me a few days ago about something he said, and I just, whatever, Remy. Whatever your agenda is, if this subject interests you, you make a video, make a commentary if you've got a commentary to make on what you think the truth is. All the documents in the case I will make public. Okay, the only reason why I haven't made all of it public is because there's a lot of fucking private information of Jones R's that I'm not gonna publish unless I have to. Okay. It's that simple, and there's some of my stuff in there that I don't really like having out there for you trollish assholes to go perusal through. But regardless, it's all going to end up out there. I'm not hiding anything. There's no deception here whatsoever. All right, so let's talk about this Rule 16 conference crap, and the fact that I just scanned it, but I got a document from Jones a while back. It wasn't a formal motion, and just this snarky letter, so I'll go over that letter in another video because frankly I can't find it right now. Yeah, this is how it was written. I mean, it was just a letter. You don't, this is not a legal doc. You don't send just letters and say I want or I expect or I demand. You got to do that in what's called a motion. Motions have this like bulkier look to them, little formal captions. Certain parts of them have to be a certain way. That's just the rules. You got to play by the fucking rules. And anyway, the idea is these courts have now come up with this conference crap. They don't bother with this in our federal jurisdiction, in our circuit. But anyway, so it's something courts can do or they can't do. But the basic idea is they're trying to get parties to settle. So they try to force parties together and force them to come to some sort of settlement without having a trial. There's nothing wrong with that as long as, in my opinion, you're not. Obviously, when people are pro se, it creates a complication because it's not lawyers meeting and arguing. You'd have to have the parties meet. So let's say there was a civil case and you were suing somebody for raping you in a civil case. Obviously, you're not going to sit down at a table and talk to this motherfucking bastard and have and I'm not going to have a civil conversation with Jones. I'm not going to talk to some fucker who sends mail to my fucking house with the word psycho in my name. I mean, fuck him. He can go fuck up. He can do whatever the fuck he wants, but I don't have an obligation to do a single goddamn thing until a judge orders me to fucking goddamn do it. And so apparently Remy thinks that because Jones R said, I want this, and I want proof of your harm, and I want this, and he has some right to some of this shit. He doesn't have any fucking right to it until we get to certain stages in the process. And the whole point of these pre-trial conferences are to debate those issues. And I filed a formal motion, the appropriate form of document, outlining, creating a format for that discussion. And but the court won't allow us to have that discussion. That's been the whole fucking problem, is that we can't have the fucking telephone conference. That if you read Rule 16, read it. I mean, it says right in it. Right the fuck in the goddamn rule. After consulting with the attorneys for the parties and any other unrepresented parties by scheduling conference, telephone, mail, or other suitable means, meaning they go out to fucking goddamn lunch apparently. But anyway, right there it says telephone. I mean, judges are supposed to be talking to us by telephone. It's not unheard of procedure. And that's why this whole thing has gotten fucked, is we haven't been able to talk to a judge and go over the issues involved in this case. And where if Jones R has some fucking problem, he doesn't understand the case, then his problem can be stated to the judge, and the judge can ask me simple questions. Well, what exactly did he do? Or she could say something like that, and I could just simply answer the fucking questions and resolve any uncertainty he has about what the cause of action is. The alternative, sensible approach is, let's go back to this is the federal rule. So this was Rule 16. So let's go back to Rule 12. And that's right, yeah. And let's go float our way down to Section What the hell happened to it? I thought it was called 8. What the hell? There's only a 6, 7. Failure to join parties. Dismissed. No. Let's see. Motion for judgment on the pleadings. No. Preliminary hearing. No. Ah, here we go. Motion E. Sorry. So 12-E of the Federal Rules of Civil Procedure. And it says right there, motion for more definitive statement. If a pleading to which a responding party is a responsive pleading is permitted is so vague or ambiguous that a party cannot reasonably be required to frame a responsive pleading, the party may move for a more definitive statement before interposing a responsive pleading. A motion shall point out the defects complained of and the details desired. A motion. Okay, Joneser can't, number one, he can't just file some dopey, silly letter where he slanders the shit out of me some more and expect anything. And if, which may be appropriate, the court says, okay, we'll call this a motion and we'll describe it as a motion for a more definitive statement. Then it says right in the law, asshole, right here. If the motion is granted and the order of the court is not obeyed. There you go. If the motion is granted and the order of the court. You see, the court has to order me to obey Mr. Joneser's fucktarded asshole request that I tell him how big my shoes are, or whatever other bullshit he wants to fucking know. But otherwise, I don't have any fucking obligations to him until we get to the discovery stage. And I have pointed out in the other motion, you can't have discovery until you get the evidence from the place where it is secured, which is fucking YouTube. I only have part of the evidence. Joneser only has part of the evidence. The only sensible thing to do is get the real evidence from YouTube. And again, some asshole cannot say I want if he's not willing to give. So until Joneser says, well, here's everything I own, everything I possess, every one of my PMs, every one of my emails relevant to this case, then he's got no fucking business asking for a goddamn fucking thing. But anyway, and the point is he asks judge's order. That's how the legal system works, Remy. He asks, the judge orders. That's how it works. It doesn't work where he orders me to do a goddamn fucking thing. I don't have to listen to Joneser's fucking orders. He can shove his orders up his ass until they come flying out of his fucking goddamn nose. I'm so sick of that fucking weasel. Because he says things in here that are just totally outrageous. In the end, he complains about the fact, well, teleconferences are at the judge's discretion, and he's giving me a lecture on this. This is from the same asshole who filed the whole whiny document about how he's too disabled to show up for the goddamn hearings when he lived in the fucking state. I mean, I filed a fucking case in his own goddamn state, and he's whining about traveling maybe 100 miles where he was expecting me to travel 2,200. The fucking bastard. So it's just shit. I mean, it's just a fucking. I mean, there's so much dishonesty in the 2 pages he sent to me. Like I said, this is not a formal motion. This is crap as legal process. And right there in the fucking law, right there's no way the judge can get around this fucking simple goddamn statement right there. I had no obligation to pay a goddamn bit of attention to this until the judge fucking ordered, me to obey, and within 10 days. And that's the way it works, So there was no fucking order for me to give Joneser a motherfucking thing, therefore I had no fucking obligation. The fucking end, you motherfucking prick. Yeah, I thought this would take more time, but it didn't. So anyway, so that's the rules, and so I will post Joneser's shit letter, and redact the obvious name, addresses, and such. And but yeah, I'm not deceiving anybody. I'm not manipulating the truth here. I'm not playing any goddamn games, Remy. You're the one playing the fucking games. You're always trying to convert and pervert the circumstance to make it seem like somehow I'm the evil one, and somehow the system's doing the right fucking thing, and you goddamn know better. And if you've read all the documents in this case, and you've read the shit that Joneser has put in his documents, and you still come up back with this crap that somehow he hasn't crossed lines all over the fucking place, then fuck you. Don't ever show up again in one of my stick-am rooms, you motherfucking cunt. You're a jackass. You're a fucking ignorant jackass. I dare you to make a video on any guy. Like I said, I'll just kick your ass again. I'll just wipe you up all over the fucking... I dare you to make a video on this subject. I dare you, you fucking cunt. Plain and simple. Don't be sending PMs to my friends ragging about me, you motherfucking asshole. Yeah, I didn't really want to add that part, but it fell out anyway. Some tough shit. I just hate all that backdoor shit. Nobody, do not send me PMs with any kind of personal information, okay, that you want to trust me with. Fuck that shit. Unless somebody's got cancer or something and you want me to raise money or some, I don't know, some other kind of deal. But anything about this personality crap on YouTube, don't send me no fucking insider dopey shit, okay, if you don't expect me to talk about it. Fuck that crap. I hate fucking secret little games and